Good morning and welcome to Raising the Bar, Greater RVA's Law Talk radio show. Today we're going to talk about multi-parenting. When can a child have more than two parents? Can a child legally really have three or more parents? And joining me today is attorney Kati Kitstein, both of us with the law firm of Locke and Quinn, which is conveniently located in the Willow Lawn Shopping Center area. So remember that Raising the Bar Law Talk radio show brings an exciting and varied array of legal topics to listeners throughout Central Virginia every Wednesday at 9 a.m. But also you can catch the show on the Locke and Quinn Facebook page, all of the video replays. And you can also catch the podcasts on iTunes on the Raising the Bar Law Talk podcast series. In addition, if you go to the Raising the Bar Law Talk radio show website, we have listed there all of the low cost, reduced cost, and no cost legal services that are available to the legal community. So the show is really trying to educate folks on different areas of the law. And today we're going to talk about this new kind of evolving area of cases where children can have more than two parents legally recognized by the court system. So if you have any questions today about that topic, please call into the show at 804-454-1366. So good morning, Kati.
Good morning, Colleen.
Good deal. Kati's just getting over the flu, so we're poor thing. She got hit by the flu along with most of the other Virginia population this winter. So, but nonetheless, she is a trooper to be here today, asking me questions about multi-parenting.
Yes, if my voice is a little lower than usual, then that is why. But so, Colleen, I guess getting started on this topic, can you explain what you mean by tri-parenting or multi-parenting?
Right. So tri-parenting, it's a little bit different than just, the grandparents having visitation or somebody having some sort of third-party visitation rights. Tri-parenting is really where the courts have recognized that there are truly three legal parents. Now, there are very few cases where the courts actually say all three parents are legal parents that have the same rights vis-a-vis each other. A lot of the cases that are out there will give two parents kind of the legal parent rights, and then the third parent almost legal standing. But a true tri-parenting case is where the court has actually said all three of you will be recognized and all three of you will be placed on the child's birth certificate, which is another evolving area of the law as well.
So is this something that's recognized in Virginia?
Not officially to give all three parents the same exact status, but we are able to get something pretty close in Virginia. And one of the cases that I handled was a case where a child had been born from a heterosexual couple, from a heterosexual marriage, and then they divorced. So we have biological dad, who was the ex-husband. We have biological mom, who's the ex-wife. And the ex-wife then remarried in a lesbian relationship. So now her wife has basically stepped in and has been helping to parent the child. And the ex-husband recognized that. So he was willing to give a joint legal custody to the new wife while he still retained his rights of, support and visitation, his responsibility of support and his rights of visitation, and also having legal custody, able to make decisions for the child. So in that case, we pretty much had the two full legal parents because the new wife did not go on the birth certificate.
Right.
She was not a parent by adoption, or she was not the biological parent. However, she had full custodial rights. So I say she got about like 85% of what a legal parent would get.
Right. And what are some of those? I mean, when you talk about the 80% of the rights, what's that gap? What's that difference between being a full legal parent and being a custodial parent?
Right. So one of the things is a custodial parent's not going to go on the birth certificate. Another thing is that the child may not receive Social Security or Social Security disability benefits from that parent as well. The child will not automatically inherit from that parent as a legal parent. That parent custodial parent would have to provide for the child in a will.
Mm-hmm.
So the child could still be provided for, but it's not going to happen
So
automatically
that'd be more deliberate.
as a matter of law. And then there's some other nuances in there, including, can you declare the child as a dependent on your tax return, and that can vary from state to state, and based on also who the child lived with, et cetera. So there's some different nuances in there, but those are some of the big factors.
Okay. All right. So what are the various categories of parents involved in multi-parenting?
Yeah, and that's really expanded. And, we do estate planning, and that's been an interesting area because a lot of traditional estate planners typically in wills would only recognize parents that were natural or by adoption. So it's like by birth or by adoption. But now we have what we consider the genetic or biological parent, but that can also be a sperm donor or egg donor.
Right.
And if you don't have a clear donor agreement, then we run into issues there. And then, of course, you can have a gestational parent. We have gestational carriers, and so they're not necessarily biologically related unless they're a true surrogate or traditional surrogate. So you can have a woman carry a child but not be the biological parent. And then we also have the presumed or legal parent by marriage, but that might not necessarily be the biological parent. We're going to talk about some of these adultery cases where, with tri-parenting, where that's where you do get the three-parent conundrum with the adulterous relationships. So, and then, of course, this evolving theory of the de facto or the psychological parent has been evolving over the last couple decades.
Yeah, and that's one that is really interesting. Can you expand a little bit more on what the psychological or de facto parent is?
So it started coming up, first of all, in some of the lesbian cases, especially a Supreme Court case out of Wisconsin, and then the Maryland Supreme Court adopted the same test as a 4-prong test. But in both cases, the lesbian couple had used a sperm donor. But, before marriage equality for LGBT families, if the marriage wasn't recognized, there were issues with, and we're slowly evolving toward, especially with the recent U.S. Supreme Court decision, we're slowly evolving to the concept of a child born of a gay marriage being the presumed child of both parents. But when you look at cases from the 1980s, 1990s, et cetera, that concept wasn't there. So basically, what started to evolve was the psychological or de facto parent. So the other spouse was parenting the child, but they didn't at the time have the same, standing as the actual biological mom. So this 4-prong test basically started to come about. And the first part of the test is, did the legal parent, that is the biological or adoptive parent, did they consent to and foster the other parent's establishment of a parent-like relationship with the child? Okay. And then the second one is, did the psychological or de facto parent live with the child in the same household? And then did the de facto or psychological parent assume the obligations of parenthood by taking significant responsibility for the child's care, education, and development, including contributing toward the child's support without any expectation of financial gain on their own? And then the fourth factor is that the psychological or de facto parent had been in a parental role for a length of time long enough to have established a relationship with the child that was a bonded, dependent relationship, and kind of a parental relationship in nature. And so, basically, in these cases, the non-marital parents, so they're not a legal parent, they're not presumed, they're not the biological, they're not the gestational parent, but they could be deemed a parent by virtue of having. And de facto means by in fact, is Latin for, de facto is in fact. Were they in fact acting as a parent? And were they doing all the things that a parent would typically do? And so if they, and psychologically, the child looks to them as a parent.
Right.
So that's where we've got this concept of psychological or de facto parent. And now that concept, that and that four-pronged test in particular is making its way into the tri-parenting cases, in terms of somebody developing standing of being a legal parent by virtue of being a de facto or psychological parent.
Okay. So I know we have different ways that these arrangements come about, these tri-parenting. You sort of have the, intentional or by design tri-parenting arrangements as one part of this. So what is tri-parenting or multi-parenting by design?
Well, there's a great Minnesota case on this, and I love this case. It's just kind of fascinating. So basically, the female parent and her female partner decide to, along with their gay friends, so two gay guys and two lesbian gals. It almost sounds like a bad joke, I know, but it's like they basically decide that that they're going to all work together to form a child. So they agree to have the child together, and originally in writing they agree that the one fellow, La Chapelle, is going to donate his sperm for the artificial insemination of the female parent, Mitten. And they decide he's not going to have, I know, great names. I love La Chapelle and Mitten. They decide in writing that he is not going to have any parental rights, and that Mitten's not going to hold him responsible for the child. So Mitten then gets pregnant in April of 1992. And in May of 1992, just a month after she gets pregnant, La Chapelle kind of has second thoughts about this whole thing. She's pregnant. I guess he starts to get some paternal feelings. And so they sign a new agreement that now Mitten and her female partner, Ohanian, I love these names, yeah, are going to have physical and legal custody of the child. And La Chapelle and his partner are going to be entitled to a significant relationship with the child. So, what happens in these multi-parenting by design cases is that everything originally by design seems to be a great plan, but then as human nature is, people break up, or or they want to move or whatever. So basically the two women allow La Chapelle and his partner to have some custody and visitation rights until around August of 1994, when they terminated the visitation by the two guys, including La Chapelle, who's the biological dad, who originally was supposed to be the sperm donor, but then they renege on that and say he's not going to be a sperm donor now. Okay. So
were they consulting a lawyer on the front end?
I seriously doubt they were.
Okay.
Most of these messed up cases are where nobody has a clear donor agreement in place, kind of like the turkey baster case out of Roanoke, Virginia, where the gal used her friend's sperm with the turkey baster, and they didn't have any agreement. And of course, she thought he was a sperm donor, and he thought he was a dad. And the court eventually ruled the turkey baster was not a intervening medical technology, and therefore he was a dad. Yeah. So yes, definitely no lawyers involved. So in this case, this Minnesota case, in September of 1993, without notice to the guys, La Chapelle and Ohanian went and got a final order of adoption, basically telling the court that the child was born the product of artificial insemination by a sperm donor. So La Chapelle finds this out after he gets his visitation cut off. And so he files to vacate the adoption based on fraud. And of course, he begins paternity proceedings. So then, to compound matters, Mitten and Ohanian, the lesbian couple, they break up in the spring of 1996 while this litigation is going on. And so all three parties then claim parental rights to the child. And so the Minnesota Court of Appeals found that a tri-partite arrangement was appropriate and gave visitation to La Chapelle, the biological father, sole physical custody to Mitten, joint legal custody to Mitten and Ohanian, and basically based the decision on the child's best interest. The court also, I believe at that point, La Chapelle was trying to move with the child to Michigan, and I think the court basically said, no, you need to come back so that you can make this arrangement work. If you're going to have this many parents for the child, we got to put the child's best interest first. So, you can't be having parents moving to different states or anything in these types of arrangements. So that was basically an arrangement by design. Well, actually, it was a four-person arrangement originally by design, which then started to come unraveled.
It's not very well planned out design, it sounds
like. Well, we see so many divorces between two-parent families that's one of the criticisms of I mean, there are good things and bad things about the tri-parenting that we'll talk about, but one of the criticisms is, now you've got three people that you're trying to all,
Right.
keep together for the benefit of the child.
Custody battles are hard enough with just two.
Exactly.
And
Exactly.
you add in more emotional adults into that, and they can get very,
right.
very
And then you
messy.
get people that want to move to different states, and
Mhm.
if you split up, and now it just becomes more complicated.
Yeah, absolutely. So, when is tri-parenting more not by design? I mean, that's one where they, at least initially, it seemed like planned to have more than
Right.
one or more than two people that were going to act as parents for this child. But I know that there are some cases where that's not the plan from the beginning, and then it just kind of ends up that way. So, what are some of those cases like?
Right. So a lot of those are the adultery cases.
Okay.
But then there's a really interesting case out of Louisiana, 2010 case, where the maternal grandmom adopts the child, because the biological parents are really not equipped at the time to raise the child. So grandma says, I'll adopt the child as a single mom. And we're seeing with the opioid crisis, a lot of grandparent adoptions, and where the biological parents are drug addicts, and now grandmom and granddad are stepping in, and it's unfortunate, but in our practice, we've been seeing a rise on the grandparent and relative adoptions.
Right.
So, in this case, grandmom adopts the child, but she continues to live with the biological parents in a duplex. The family unit lives kind of in a duplex, with the biological parents living in one unit on one side and the child living with grandma on the other side. And then the biological parents end their relationship, and the biological father moves out. But then grandmom gets into very bad health. She gets really sick.
Okay.
Okay. And so the Supreme Court of Louisiana says that because grandmom adopted the child, the parents were actually non-parents at that point, and grandmom was a parent because she was the adoptive parent. Adoptive parents step into the shoes and become a full, legal parent. But now grandma is really not in a position to care for the child. So the court basically fashioned a tripartite custody arrangement, again in the best interest of the child, and basically gave a joint custodial arrangement to all three. So grandmom's, she's still there, but she just can't physically care for the child now that she's in bad health. Gave primary custody to the mother, the biological mother, who is now kind of stepped back up to the plate. But biological dad still has he still has his custodial parent rights kept intact as well. So that wasn't by design at all. It was just kind of by virtue
by circumstance.
of right. And the same thing with the adulterous arrangements, because what happens there is either the wife has an affair or the husband has an affair, and then they continue to allow the person they had the affair with to have an ongoing relationship with the child. And so their spouse is kind of the presumed legal parent, but then the person they had the affair with, who's the biological parent. And so there are quite a number of cases out there as well. So we've got a caller on the line. Charlie, good morning.
Good morning.
How are you?
I'm well.
Good. You've got a question for us this morning.
Yes, I was wondering, with this tri-parenting, is it just with same-sex couples, or is it just similar to just like a custody arrangement, just with the third or fourth party?
Well, it can be both, Charlie. That's an excellent question, because just like in the Louisiana case with the grandma we were talking about, you can have all different arrangements. You can have grandma with biological mom and dad. You can have the adulterous, affair person along with the married couple. You can have, there's a case too that I studied where you had a neighbor. So we had biological parents who placed the child with their maternal aunt, and then the maternal aunt allowed the neighbor to help co-parent the child. So we're seeing all sorts. It's not just limited to LGBT or same-sex couples.
Right.
It's all different types of arrangements that are out there that are being formed, where it's basically you have more than two people parenting the child.
And I would imagine in step-parent cases, you probably get this a lot too, where you have a step-parent who's really stepped in to be a parent, but a biological parent who hasn't necessarily stepped out of being a parent. And I know that's an issue that comes up a lot when we do these cases in our office is, in Virginia, we're still having to terminate the rights of one parent in order to put the step parent in that place. But I would imagine there's some cases where maybe the parties don't necessarily want to do that.
There are.
Yeah.
That's another good example, Katie, of these tri-parenting arrangements where you have step parent now who's pretty much stepped in as the third parent.
Mhm.
Yeah. So did that answer your question, Charlie?
Yes, ma'am.
Great. Thank you so much for calling into the show.
Thank you.
All right. So the step parent cases, that's another one which is not necessarily by design. You know, I mean, people don't intend to divorce and remarry necessarily.
Yeah.
It's not kind of planned out in advance.
Yeah, but you can, end up where a kid really does have, 3 people that are parenting them and that they feel like are, their parents in some of these cases, I would imagine. So when did cases like this first start getting reported?
So there are a lot of cases out there that are unreported, and that's kind of the problem in this area. And I'm writing an article on the International Academy of Family Lawyers, and so trying to kind of get a handle on because there are a lot of through networking. I've found there are a lot of unpublished cases,
Right.
but one of the kind of the seminal big cases that started looking at this concept that's right out there front and center is the U.S. Supreme Court case of Mitchell H. versus Gerald. I think it's Gerald V. And that case basically started with a child that was born in 1981 in California, and it was Gerald D. Yeah, so it ended up being a 1988 case, but it takes a long time for cases to get to the U.S. Supreme Court level. So in that case, basically the child's born in 1981. This is one of the adulterous cases. So mom has an affair. Her husband is put on the birth certificate. Mom ends up leaving her husband and goes and lives with the biological dad with whom she had the affair with. She holds the child out as the biological father's, but she's also still letting the child have visits with the husband. Obviously, this child probably is confused about who his real dad is.
Right.
And she ends up getting back together with the husband in 1984. And so basically, biological dad says, no, I'm dad. And husband's like, no, I'm dad. And so that's why you have Michael H. versus Gerald D. It's bio dad versus legal dad husband. And so in that case, we're going to come back after the break and tell you what happens.
You've been listening to Raising the Bar, Greater Richmond's premier law talk radio show. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
With SRN News, I'm Rich Thomason in Washington. The Brits are expelling almost 24 Russian diplomats after the nerve agent attack that seriously injured a former Russian double agent and his daughter in the UK. Retail sales, key part of the U.S. economy, hit a speed bump last month. They declined by 1%. A tight Pennsylvania congressional election, the contest between Republican Rick Saccone, Democrat Connor Lamb, remains too close to call, although Lamb, with a slim lead, has declared victory. Now formally facing the death penalty, Nicholas Cruz, a suspect in the Parkland, Florida school shootings, due in court today for arraignment on a 34-count indictment. On Wall Street at the open this morning, the Dow up about 108 points, the NASDAQ 28 points higher, the S&P is up 11 points. More details at srnnews.com.
The following is not an actor, but a real-life story from Trinity Debt Management.
It's probably been about 10 years ago. I had quite a few credit cards. The interest on the cards was really high. I was making the minimum payments, but barely. And it was just getting to be too much, so I called Trinity.
If you're in debt and you need help, call Trinity at 1-800-990-6976 to talk to a certified counselor.
They met with me, and they were able to get all of my credit cards in one lower payment.
Trinity will consolidate your accounts into one easy-to-manage monthly payment, put a stop to late fees and over-limit charges, reduce your interest, and possibly improve your credit score. You'll save thousands.
They did help me learn how to manage my money. Now, we have a house, and we're doing a lot better.
If your debt has you down, call Trinity at 1-800-990-6976.
My name is Holly, and I am debt-free for keeps.
1-800-990-6976.
WNTW listeners, we here at AM 820 and 97.7 FM The Answer would like to congratulate our listeners Keith, Randy, Ken, Guy, and Oscar for each winning one of the 5 $100 Ruth's Chris Steakhouse gift cards during our February contest. And we're excited to announce that we are extending the contest into March. That's right. Again, this March, there will be 5 winners. Just call into any of our participating live and local shows with your relevant stories, comments, or questions, and you will automatically be entered to win one of 5 $100 Ruth's Chris Steakhouse gift cards. You have another chance to enjoy an unparalleled dining experience at the Ruth's Chris Steakhouse located at the historic Belgrade Plantation. Again, on us, we're just saying thanks because we here at WNTW know that it's you, our listener, who makes our station great. Go to 820theanswer.com/radio for contest details. That's 820theanswer.com/radio for contest details.
Now, back to Raising the Bar. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
We are back. This is Raising the Bar, Greater RVA's Law Talk radio show. And today, this is Colleen Quinn of Lock and Quinn. Today, Kati Kitstein and I are talking about multi-parenting and the concept of when a child can have more than 2 parents and can actually have 3 legal parents. And right before the break, we were talking about one of the U.S. Supreme Court cases that really put the spotlight on this issue. It was a 1988 Supreme Court case, but we were talking about the child was actually born in 1981. And so that is this case of Michael H. versus Gerald D. And just to diagram it out again, because some of these cases could be a little bit confusing in terms of how these 3 parents come about. But basically, mom, and this is a case out in California, mom has an affair during the marriage. And so then when the child is born, based under California law at that time, her husband goes on the birth certificate. The reason being is that there are a lot of states out there where you want the child to be born not out of wedlock. You want the child to be born in a legitimate marriage and not be a bastard. So basically, her husband goes on the birth certificate, and actually there's DNA testing done at the time, 1981, which shows that the man she had the affair with is actually the biological father. So mom leaves the husband and goes to live with the biological father and basically holds the child out as the biological father's for a period of time. But husband is still involved in the child's life because he stepped in as dad. Okay. I don't think he knew he wasn't dad initially.
Right.
And then she goes back to the husband in 1984. And so now both men, Michael H. and Gerald D. are now claiming that, hey, we're dad. So, the court has to say, okay, well, which dad are we going to recognize as the legal dad? And in that case, the guardian ad litem, which is the attorney for the child, okay, basically, the guardian ad litem argues that the child should have both dads, that the child has due process rights to maintain a filial relationship with both Michael and Gerald. And basically, the court says, well, even though the guardian ad litem says that this arrangement can be a great psychological benefit to the child, California law at this time does not allow for there to be two dads. So basically, the court says, in this case, because mom was married at the time, then her husband has to be the dad, not bio dad, not the biological father, which you would think that doesn't make sense. But in the interest of saying this child's not going to be a bastard, that was the court ruling. So interestingly enough, California law has since changed. So California law expressly, it's one of the few states that actually has a statute, California and Maine, that actually says now in both its family code, two parts of its family code, that a child can have more than two parents. So if that case were brought now before the U.S. Supreme Court, I think it would have a completely different outcome, where the U.S. Supreme Court would have to say, yeah, we're going to recognize both the presumed dad, that is the husband, and we're also going to recognize the man that she had the affair with, who's the biological father, both of whom who have stepped in to be parents to this child.
Yeah.
I think would have a completely different outcome.
I'm also curious, in 1988, if the court was worried about the precedent that would be set by saying you can have two legal dads on, if you're both acting as parents.
Right.
So I wonder how much of that was playing into this case, even though this was, not a case that was, it was heterosexual couple and the guy she had the affair with. But I just wonder how much the court was thinking, like, what happens if we say, yes, this child can have two dads.
Right. And then
in 1988.
And you've got, it goes against, tradition. It goes against certain religious views. We've got the issue of the child being born out of wedlock. How does that affect the child? Who's going to be responsible for child support? Well, if both dads are, actually, that's a good thing for the kid.
Right. One more source of
more people to pay for the college education or whatever.
Absolutely. So you mentioned this a little bit before the break, but all of these cases of tri-parenting, or three or more people getting recognized as parents, are they getting reported regularly? Is it something easy to track? Or
no, it's so hard to find. So through like the Academy of Adoption and Assisted Reproduction Attorneys, and through the LGBT bar, and like you basically, and if you Google this topic, you'll see articles where it's referenced. Oh, there's cases in Alaska, and there's cases here and there. But a lot of it's anecdotal, because you've got attorneys that are just going to the juvenile court, and a lot of those cases are under seal, so you can't research and find them. So there are a lot of unpublished or unreported cases out there to try to really get a handle on what's going on and how many of these tri-parenting cases, how many of these tri-parenting arrangements have been actually fashioned. It's hard to get a good handle on how many there really are out there.
Yeah. So I'm guessing, and this is something we haven't talked a whole lot about yet, but I imagine that with assisted reproductive technology and the evolution that we've had in that area lately, how has that contributed to sort of this rethinking parenting arrangements and the law?
Well, I think it's contributed enormously, especially when you have somebody that is donating sperm or donating their egg. You've got women where they're in a committed relationship where one will contribute her egg to her partner to gestate along with donor sperm. And if you don't have very clearly delineated donor agreements, you don't have lawyers involved.
Right.
Remember we talked about the turkey baster case out of Roanoke, Virginia. Then you run into some issues about who's the parent, because is that person really a donor, or is that person a biological parent? And we talked about the Minnesota case with, LaChapelle, who originally started as a donor and then decided he was going to be a dad. And that happens quite a bit, where we have these donor dispute cases.
Yeah. So are there any, I know you mentioned California, but are there any states or countries who permit tri-parenting by actual statutes in addition to California?
Right. The ones that I'm aware of, and I'm still kind of researching, but Maine has a statute in addition. We talked about California statute, and California actually in 2011 had a case where the child's biological mom and the biological mom's wife and the biological father were all declared to be presumed parents. So that case in 2011 was kind of a precursor to the two statutes enacted in California in 2013 and 2014 that recognized that legally you could have more than two parents. And they don't in this California statutes, they don't limit it to like three parents. It's just one of the statutes says that in an appropriate action, a court may find that more than two persons with a claim to parentage under this division are parents if the court finds that recognizing only two parents would be detrimental to the child. And then it basically says the court has to consider all relevant factors, including the harm of removing the child from a stable, placement, the child's physical needs, the child's psychological needs for care and affection, et cetera. So it kind of goes into that psychological parent test. So there presumably could be 4 or 5 parents under California statutes. Now there's a statute in Maine, and there's not a whole lot on it, but it was enacted in 2016. And basically it says that preservation of a parent-child relationship consistent with the establishment of parentage under this chapter, a court can determine that a child has more than two parents. So again, that's not limited to 3 parents either. Arguably in Maine, you could have 4 parents, 5 parents. And I haven't been able to find a whole lot in terms of how that statute has played out yet in Maine. And then in Canada, it's only in certain provinces that they've recognized that a child can have more than 2 parents. And that actually that was the statute in 2016 in Ontario. And actually prior to that statute, the Ontario Court of Appeals in a 2007 case recognized that there could be 3 parents in this case of AA versus BB. And again, this is one of those ones where you have to kind of diagram it out. But anyway, in that case, A and her partner C had been in a stable same-sex union. And then they decided to start a family with the assistance of their male friend B. Okay. So
A, B, and C.
A, B, and C. And again, one of these, kind of let's all have a child together by design. And they decided that it would be in the child's best interest for B to remain involved in the child's life. So you have biological mom and biological dad, who are the child's legal parents. But they also want A, the non-biological parent, who's the wife of the biological mom, to be recognized as a mom. And A and C did not want to get an adoption order because that would cause B to lose her status. So A brings an application for a declaration that she's the child's mom. And while the court says that there's a legislative gap in this case, they want children all to have equal status, and quality of status for the child means recognizing all of that child's parents, whether born in or out of the marriage. And so basically that case says we're going to recognize both moms. And in that case, the child actually at that point, it was in her teens, and she said, I just want both of my moms recognized as my moms. And the court in that case said it would help the government and the law, would help if the government and the law recognize that I have 2 moms. This is what the child said. It would help more people to understand. It would make my life easier. I want my family to be accepted and included just like everyone else's family. So, this child has 2 moms and a dad, and want it to feel like I want to be able to hold them out, as legitimate and legal. And the court said, yep, this is in the child's best interest. And then not long after that, then we have the Ontario statute that says you can have more than 2 parents, but we have to, the way Canada's broken up, that's kind of just limited to one part of to one part of Canada, which is Ontario. So those are the countries and states with actual statutes. And then we get into the issue of, is there case law, which is different than statute. Statute would be the legislature actually issuing a statutory provision that this is blessed by the legislature, as opposed to being fashioned by the courts with case law.
Okay. And I imagine in these cases, especially when there aren't statutes, they seem to be really fact specific. I mean, when you're looking at this best interest of the child, standard, that's the court's really going to take a close look at, what is really going on in the situation, what are the relationships of all of these parents to the child, and what's really best. I mean, in that case, you have a teenager who can sort of speak for themselves and
Right.
and talk to the court. But it seems like these are all really case by case before you have a statute on the books.
They are, and some of them, folks are fighting, but in the cases where they all say, yes, we want, we're one happy family, this, AA versus BB, they're like, look at, this is working. We're, we've got a great 2 mom, 1 dad arrangement for this child, and it's working for the child, and the child says it's working. So it's kind of hard for the court to say no to blessing all 3 parents.
Right. Really interesting. So what about putting more than 2 parents on a birth certificate? Do these places that allow it by statute also allow that, or is that allowed anywhere?
Yeah, and it gets a little bit more complicated because you've got cases out there where the court finds that there are in fact 3 equal legal parents, but they don't have a statutory scheme that allows all 3 to be put on the birth certificate, and then it becomes a little bit more complicated in terms of, okay, well, which ones do get to go on the birth certificate?
Right.
But in terms of cases that we know about, we know that in Florida, that at least 3 people, 2 moms and a sperm donor, but he really wasn't a donor because if you're a donor, you're basically not a parent. But in this case, the biological father and the 2 moms were put on the birth certificate in an unpublished opinion in the Miami-Dade Circuit Court. So again, it's an unpublished opinion, so but it apparently is out there. And then both Argentina and Brazil have allowed all 3 names to be placed on the child's birth certificate. The Brazilian case is, again, 2 married women and a male friend who helped them conceive the child. And the Argentinian case also was a same-sex couple and the biological parent, again, 2 women and a man who basically all went into a tri-parenting arrangement. So Argentina and Brazil and Florida are ones that we know that the child actually got placed on the birth certificate. And I suspect there are more out there. It's just hard to try to track them down.
Right, because so often these things are confidential and are sealed, and they're not, not always just readily available to research. So we've been talking a lot about the specific cases, but I know that as this has evolved, it's sort of become a hotly contested issue on both sides. So what are some of the arguments that people have against these tri-parenting or multi-parenting arrangements?
Right. So we kind of alluded to it a little bit earlier, but one of the arguments is, good grief, look at the divorce rate as it is. Between 2 parents, now you're going to throw in a 3rd parent or even a 4th parent. I mean, my goodness. Now let's look at what these custody battles are going to look like, because now we're going to have more fighting. Of course, the counter argument to that is actually there are some arrangements out there, like the Canadian case of AA versus BB, where actually the tri-parenting arrangement was working just perfectly fine. So, some folks that are more on the conservative religious side feel that a child should just have 2 parents that are the 2 legal parents that are married to each other. So, and that goes back to that U.S. Supreme Court case, that rose out of California. The argument is that we shouldn't be recognizing parents of a child born out of wedlock. So the legal presumption needs to be that it's the husband and the wife, or the wife and the wife, or the husband and the husband. Now that we have marriage equality, and it shouldn't be some other 3rd party. So it's kind of the argument that it's steeped in tradition and accepted family structure and accepted marital presumptions of the child being born of the marriage. So that's basically one of the strong arguments. Another one is that a concern about abuse, that this is, where are we going to stop this? Like, can having multiple parents basically allow cults to form, where basically a number of parents can all have some sort of cult control over the child. Why not form a commune or a religious organization or a sect, where we're bringing these children in and they're being parented by 4 or 5 parents. So there's this concept of how far are we going to allow this to go?
Mm-hmm.
And of course, what truly is in the best interest of the child, and that cuts both ways, both for and against. It just depends on the level of conflict in the multi-parent relationship.
Okay.
So those are some of another one is a lack of stability for the child. Some people argue that having more than 2 parents, the child's going to be unstable and confused. That flies in the face of the counter argument that the more parent the child has, the greater the stability. So you've got
Yeah, people arguing both sides of it.
Right.
So what are some of these arguments in favor of, obviously courts have started to recognize this, state legislatures have, a couple of them have started to recognize this. So what's the basis for that?
Well, some of the biggest argument is that just more people to love the child, love and raise and be able to pool financially together to benefit the child. And so that if the child truly has more than 3 people, and it's not limited to, same-sex relationships or adulterous relationships, but you mentioned earlier, Katie, the step-parent relationships where there really truly are, 3 parents that are all stepping in to help parent the child. We've got, grandma and relative. We've got other relationships where, other people are stepping in and doing the hard work of raising a child. So another argument is just fundamental human rights, that humans have the right to define their identity the way, both in a practical and an abstract sense. And so another one is that why discriminate? You got parents in a tri-parenting arrangement. Why be discriminatory about that? And we've got the TV show at Three's Company, and so, the other thing is equal footing among parents. So again, okay, so you had the affair. Well, why should the biological parent, basically who you had the affair with, why should they be precluded from being a parent? Why should they be punished? Because they were in the affair, but
right.
They did basically conceive the child. Scientific advances, of course, you mentioned assisted reproductive technologies. That's kind of changing the framework. And, we've got changing societal norms. Just over time, that and honoring parties' intentions. If people want to form different types of parenting structures and they can make it work, why limit it?
Well, and it sounds like in a lot of these cases that by the time they get to the court, the parental relationships between the child and these people, that's happening anyway, whether or not the court or the state recognizes, these people as legal parents, they essentially are in a lot of these cases, even without the, the court order or the birth certificate or whatever, thumbs up from the government they're getting. It sounds like it's already happening.
Right.
In these cases anyway. So is there any historical basis for this, or is this just a totally new idea?
I was thinking about this because, I'm a scuba diver, and I was thinking, if you look at dolphins, okay, so, there is a lot of human history here too, but just look at animal behavior, okay? So, my husband and I were scuba diving on one trip, and we had the first pod of dolphins go past us. Well, the way dolphins are is the first pod is of all the scouts, and those are the males that typically swim as couples, and they are the scouts, and they swim in the first pod, okay? And then the second pod that went past us, which was really beautiful and amazing, was the nursery, okay? And in the nursery, you have the mothers and the sisters and the grandparents, all, and it literally, the dolphins, you have the big dolphins with holding the fins of the babies, and and the younger junior dolphins. And so the nursery pod is consists of all of the woman, the the ones that have hooked up with the scouts that are, the male guys, the ones that haven't, the sisters, the mothers, the grandparents, that they're all essentially parenting the junior dolphins.
Yeah.
Okay, so we have this in animal behavior. And then when you think about certain aspects of the Mormon church, certain close family units, tribal units, nomadic units, if you think about folks traveling together, gypsies, if you think about folks living in communal areas, Indians, Eskimos, if you look at just families that live together and are close together, more and more we've got grandmom and granddad living in the home. And so you can see that in many cases, just as a matter of families that stay close together, that you oftentimes will have several different adults acting as parents.
Whole concept of it takes a village to raise a child.
Exactly.
That's very true in some different, kind of community arrangements.
Right.
So is this a movement that we are looking at continuing either by statute or by case law or just by practice?
I think we are. I mean, if we look at kind of the evolving things that are happening around the world, we look at the published case law that we know about. We look at the unpublished case law that we're becoming more and more aware of. Those cases just through networking and anecdotal, and then there are a lot of news reports because I think this subject is of interest to a lot of journalists. We have the evolving statutory law. We're seeing California, Maine, and Canada. Okay. We're also seeing now the evolution of 3 parents being put on the birth certificate in Brazil, Argentina, and in Florida that we're aware of. And so with you add in same-sex marriage, you add in the opioid crisis where we're seeing, grandparents and relatives stepping in to assist biological parents. You add in the concept, the fact that we have so many divorces and then we have step-parents stepping in. You have all these different factors that all lend toward this evolution of recognizing more than 2 parents. And I think that's going to be the direction we continue to head in. With all of these different variables occurring.
Yeah, definitely. And I'm just thinking, some of it seems like in the cases that are going to court, I was thinking when you mentioned earlier about, people making that slippery slope argument, like, oh, where's this going to end? Or what about cults? What about, but in every case that you mentioned, the court has looked at the facts of that case, and it has been very fact specific. It's not this carte blanche, all right, anybody go out and, sign up to be a parent on this child's birth certificate. The courts are actually looking like, okay, who are the parties? What is their relationship? And is this in the best interest of the child? So,
right. I mean, it's not just willy-nilly. You go back to the Wisconsin 4-prong de facto psychological parent test, and that's a pretty steep test to basically say that this person has truly stepped in as a parent. So join us next week when we do part 2 of single dads and foster care, and join me with Joel Elston. It'll be a great show, and we're going to really focus on the foster care system. Thanks for having us today on Raising the Bar.
Where is the best news and talk? AM 820, WNTW Chester is the answer.
Breaking news this hour from townhall.com. I'm Rich Thomason. They're being shown the door. 23 Russian diplomats being expelled by Britain. It follows a nerve agent attack that seriously injured a former Russian spy and his daughter in England.
This will be the single biggest expulsion for over 30 years. And it reflects the fact that this is not the first time that the Russian state has acted against our country.
Prime Minister